this. Well, good morning, everyone. This hearing of the Subcommittee on Conservation, Energy, and Forestry to review the impacts of the Endangered Species Act and related litigation on the National Forest System management will come to order. I want to thank everybody for and want to welcome everyone to today's subcommittee hearing, which will focus on the impacts of litigation stemming from the Endangered Species Act and related laws. This subcommittee has held several hearings examining ways in which Congress can ensure that the Forest Service is better able to manage our federal, state, and private forests, and today's hearing continues that efforts. Beginning last May, I had the privilege of serving on a Republican congressional working group led by Chairman Doc Hastings of the Natural Resource Committee and Representative Cynthia Loomis, examining a variety of issues concerning the Endangered Species Act. Now, a copy of the final report has been distributed to all members, and without objection, it's going to be included in the record of this hearing. Now, I recognize that this subcommittee does not have legislative jurisdiction over the Endangered Species Act. The interaction between the law and others within our jurisdiction, as well as the implications of this law for our foresters, our farmers, and our private landowners is significant. The ESA first enacted in 1973 to preserve, protect, and recover key domestic species has certainly enjoyed many successes. 40 years later, as we have identified many strengths of the law, we have likewise identified many weaknesses. The working group report details many of these deficiencies and lays out a roadmap for what I'm hopeful will be a bipartisan effort to review, to reform, and to strengthen the law. While any hearing on the Endangered Species Act could include a laundry list of items, today the panel will just focus on its attention on issues related to the costs of litigation. And one of the most frequent statutes used for litigation has been the Endangered Species Act. And during several of our hearings on forest management, a recurring theme among witnesses has been how frivolous litigation has delayed needed forest management activities. Now, like many environmental laws, the ESA includes a citizen supervision which authorizes citizens to enforce compliance with any provision of the Act. In a citizen suit, the court may grant an injunction and award attorney fees and litigation costs to any prevailing or partially prevailing party whenever the court determines such an award is appropriate. Now, citizen suits have been and continue to be a useful tool in checking the actions of the executive branch. However, these lawsuits can have far-reaching negative consequences when abused. Today, we will examine how citizen suits have impacted our private and public forests. Throughout the 40-year history of the Endangered Species Act, the Forest Service, perhaps more than any other federal land management agency, has adopted policies and procedures which have greatly enhanced the scientific approach taken to manage resources under the service's care. Now, likewise, the Forest Service has gone to great lengths to improve the transparency and the public partnership in its decision-making process. And despite these tremendous efforts, the service continues to be stymied by an increasing number of frivolous lawsuits. A recent study published by the journal Forestry examined 1,162 lawsuits filed against the Forest Service between 1989 and 2008. Though the Forest Service prevailed in most of these cases, I think we'll hear today that neither the service nor the supporting agency it relies on have any way of tracking the man-hours and budgetary resources diverted from essential activities, and I would argue activities to make sure our forests are managed in a healthy way to defend against these frivolous claims. This resource drain is a flagrant abuse of taxpayer dollars. Now, we'll also hear from private landowners whose day-to-day businesses are negatively impacted by these lawsuits. Now, while this subcommittee tends to focus on the economic impacts of farmers and foresters, we would be remiss if we didn't also examine the implication of these lawsuits on the species that we're trying to protect. Now, when the Forest Service is prevented from implementing timely management decisions to sustain forest health, how can we assume that we are complying with the goals of the Act to preserve, protect, and recover threatened and endangered species? Now, this is a complex issue. I I don't expect us to enact the necessary reforms overnight, but I expect the attention of the subcommittee, and I look forward to the testimony of the witnesses who will have their expertise on this topic. And I want to thank you to the panel for taking time to be here today, and I now yield to the ranking member for his opening statement.
Well, I thank the chairman, and I want to thank each of you for taking time out and helping us understand this complex issue. This committee has a long, storied history of bipartisanship. We've proven we can do it. We got a farm bill done when many didn't think so, and I'm proud of that work we've done. But I would be remiss if I didn't say I'm a little frustrated with today's hearing. The working group that the chairman speaks about, I think is an interesting and exciting proposal, but we got no invitation to join that. And there's many members on this side of the aisle that would have gladly taken that opportunity because we understand the complexity of this issue. We certainly understand the impact and legitimate concerns on private property owners. And with 80% of those species being the species that we're talking about being on those private lands, we need partners that we're working hand in hand with. This can't go without that. We also respect biological diversity. And so our frustration is that this is a broad issue. There's jurisdictional issues here. Not being included in this puts up unnecessary partisanship where it doesn't need to be. You're going to find sympathetic ears who understand this issue. My good colleague from Oregon is an expert on this and a champion of making this work right. And these are folks that want to be included. So we're rushed on this. We had witnesses that we wanted to bring on this side and did not have the opportunity to do so. And again, it's not for the sake of trying to create a partisan issue. We simply weren't invited, Mr. Chairman. So I hope in the future you'd know many of us on this side have over years developed strong bipartisan credentials and willingness to find the issues on this. And so I'm interested, and I'll submit my entire opening statement for the record, but I think as we approach this, and I see so many things on this that, yes, there's things that we can do better. No one has said it was perfect, but I also think when I see some of the language coming up that only 1% of species have been delisted, the intent of this law is to not have species go extinct, and 99.5% that were put on there have not. So the perspective on this is of trying to strike that balance between private land ownership and economic activity, which is an absolute legitimate concern and should be there, making sure there's not onerous burdens put on those landowners, but also looking at it is let's have an agreement. Do we wish to have biodiversity and protection of species? Because it's a legitimate point if you do not believe that, but not under the guise of trying to say that it's ineffective because we've delisted, because I would offer this up. The Florida Panthers Recovery Plan is 114 years long. I'll probably be long gone before that one's delisted. It doesn't mean it was a failure. So with that, I look forward to your testimony. I look forward in the future to playing an active role in this. We want to. We need to. My landowners want us to. And I am more than willing to do that. Just ask us, and we'll be there. With that, I yield back.
I thank the gentleman, and just to note that in terms of our committee, we've been working on forest health, and this is really our first within the Agriculture Committee and this subcommittee. This is the beginning of this process for us. Any working group that happened in the jurisdiction of another committee, gives us an opportunity to make sure our forests are healthy. So this is the start of the process for us. The chair would request that other members submit their opening statements for the record so the witnesses may begin their testimony and to ensure that there's ample time for questions. And I'd like to welcome our panel witnesses to the table. Our panel one are Mr. Jim Pena, Assistant Deputy Chief, U.S. Forest Service, Ms. Eileen Lawrence, Director, Homeland Security and Justice, U.S. Government Accountability Office, Mr. Alva Joe Hopkins, President of the Forest Landowners Association from Folkston, Georgia, and Dr. Greg Scheidwachter, President of the Watershed Results in Arlington, Virginia. Written statements from the witnesses will be made part of the record. And Mr. Pena, please begin when you're ready. We have a light system in front of us. You'll see as we get, it'll be green. You kind of give you a heads up when you got about a minute to go, and it'll turn yellow and red. We just ask that, whatever thoughts you're on, you just smoothly wrap up that thought at that point. Thank you, sir. Go ahead and proceed.
Thank you. Good morning, Chairman Thompson, Ranking Member Walz, and members of the committee. I appreciate the opportunity to discuss the Forest Service role in implementing the Endangered Species Act, ESA. The ESA's purpose is to conserve threatened and endangered species and their habitat. Managing species habitat, including threatened and endangered species, is an integral part of the Forest Service mission. About 20% of the ESA's listed species have habitat within the 193 million acres of the national forests and grasslands that we manage. There are costs associated with protecting and recovering listed species. We have direct costs implementing the ESA and costs associated with litigation. Sometimes there are indirect costs, such as project delays or cancellations. The Forest Service's role in implementing the ESA is ensuring that relevant sections of the Act are integrated into forest plans and project decisions. The Forest Service assists in conserving and recovering listed species under the ESA, specifically by undertaking recovery efforts as defined by the Fish and Wildlife Service and the National Marine Fisheries Service for listed species under Section 4, and consulting on actions where the agency determines that the action may affect a listed species or its designated critical habitat, and to lessen the impacts of incidental take under Section 7. In addition to ESA, the Forest Service operates under many other laws passed by Congress. These laws give us not only the authority to manage our national forests and grasslands, they guide us in how we manage them. Within our authorities, we manage a wide variety of resources for multiple uses, and sometimes it's difficult to strike a balance. Sometimes litigation results from trying to strike a balance. According to a recent study by Minor et al. In 2014, the Journal of Forestry article, analyzing a 20-year period between 1989 and 2008, the majority of cases filed against the Forest Service concerned vegetation management projects alleging violations of many laws. Cases citing ESA violations comprised about 18% of all Forest Service land management cases. During this period, the Forest Service prevailed in 52% of the cases involving ESA. The Forest Service measures some costs associated with litigation. For example, we can account for costs associated with the Equal Access to Justice Act, which is about $875,000 per year for all land management litigation in the agency. Other costs, such as redirecting staff from other priority work and the resulting delays or cancellations of projects, are not tracked by the agency. The Forest Service is committed to managing the national forests and grasslands on which many species depend as part of the natural legacy that we leave for future generations. This concludes my testimony, Mr. Chairman, and I'm happy to respond to any questions that you or other members of the committee may have regarding our implementation of ESA.
Ms. Lawrence, you're recognized for 5 minutes.
Thank you. Chairman Thompson, Ranking Member Walz, and members of the subcommittee, I'm pleased to discuss the results from our April 2012 report with some recent updates on attorney fee claims and payments. Mr. Chairman, as you know, that select laws such as the Endangered Species Act and more generally the Equal Access to Justice Act in part provide that the federal government reimburse parties for attorney fees and costs when the parties win a lawsuit against the government. Payments are made either out of the Treasury Judgment Fund, which is a permanent and indefinite appropriation, or from the respective agencies' appropriations. The intent was to level the playing field, to make sure that individuals or parties were not discouraged from suing agencies for unreasonable program activities for fear of the cost of doing so. However, as you recognize, Mr. Chairman, some in Congress were also concerned that parties, such as environmental groups, were using taxpayer dollars from agencies' limited funding to sue the government. We were asked to determine the extent to which the Departments of Agriculture and Interior had information available on attorney fee claims and payments for fiscal years 2000 through 2010. My testimony today summarizes our findings in the Agriculture Department. In a nutshell, all but 4 of Agriculture's 33 agencies and offices in our review did not track these attorney fees, costs, and payments. Therefore, neither we nor agriculture could comprehensively answer Congress's questions about how many payments parties claimed, how much agriculture paid out, to whom and under what statute. Agencies said they did not track these data generally because they weren't required to. They didn't have many of these lawsuits, payments were minimal, and they did not need the data on payments to manage. On the other hand, the 4 entities that did track or compile these data said that doing so increased transparency and accountability and provided these entities with data to develop budget estimates, among other things. We know that the Congress has also considered legislative proposals aimed at increasing the transparency and accountability over such fees, costs, and payments. Focusing more specifically now on the 4 entities that did track or compile these data, even their information was incomplete. These entities did not always know the amount of claims denied, who received payments, the amounts paid, which could differ from the amounts awarded, and the authorizing statute. Nevertheless, we were able to report some limited data. For example, a manager within the Forest Service collected portions of these data in an electronic spreadsheet to help the agency track and assess fee claims and payments, such as determining if fee amounts for new claims were reasonable based on past claims. We reported that the Forest Service faced about $16.3 million in attorney fees and costs in 241 environmental cases during the 11 years in our review. The Forest Service did not track the associated statutes, but representatives surmised that most claims were likely under the National Environmental Policy Act, the National Forest Management Act, or the Endangered Species Act. Individual award amounts ranged from $350 to about $500,000. And payments could have come from either the Forest Service's appropriations or the judgment fund. Beginning in fiscal year 2009, in response to an appropriations request, the Forest Service now uses a unique code within agriculture's financial management system to track attorney fee payments under the Equal Access to Justice Act that come from the agency appropriations. The Forest Service, in its fiscal year 2014 budget justification, reported that it had annual payments of about $1.5 million, $500,000, and $1.6 million, respectively, from fiscal years 2011 to 2013 under that Act. We also reported that over 10 years, through September 2010, Treasury made 187 payments, totaling about $16.9 million from its judgment fund on behalf of agriculture. The highest payments were about $9 million under the Equal Credit Opportunity Act, $4.4 million under the Civil Rights Act, and $1.6 million under the Endangered Species Act. Finally, we recognize that litigation costs are broader than attorney fees and may include costs such as damages awarded and hours that agency personnel spend preparing for a case. While these costs were not a focus in our prior review, we have learned that USDA and the Forest Service likewise track some, but not all of these broader costs. Mr. Chairman, this concludes my testimony, and I would be happy to answer any questions.
Thank you, Ms. Lawrence. Appreciate it. Mr. Hopkins, you're now recognized for 5 minutes.
Good morning. The Forest Landowners Association are landowners who own and operate more than 40 million acres of private land in the United States. I'm the manager of our family timberland, some of which have been owned for over 100 years. As recently as 2 weeks ago, a coalition of prominent activist groups sent letters to 19 forest landowners and timber companies whom the activists believed might be considering the purchase of 5 parcels of forest land that were for sale. The 7-page letter warns that if you purchase any of these parcels, we intend to commence litigation to obtain an injunction to prevent you from taking any action that would result in harm to or take of a threatened or endangered species. The letter also states that in the event of such litigation, the groups will seek to recover their costs and fees, as well as the fees of their expert witnesses under the citizen enforcement provisions of the ESA. These threats were made despite the fact that, as the letter concedes, listed species had not been located on more than half the parcels of land. Needless to say, the cost to a private landowner of defending such a lawsuit, let alone facing the prospect of future litigation over the other side's costs and fees, is daunting. That such tactics will increase in my part of the country is also a real concern to forest landowners. The regional Southeast Regional Office of U.S. Fish and Wildlife Service has been swamped by lawsuits from activist groups that are designed to trigger the obligation to make the decisions about whether to list a species under the inflexible and very tight time frames provided for by the ESA. Presently, the Southeast region is obligated to make decisions regarding whether or not to list more than 400 species over 12 states in the Southeast. Massive decisions are being faced by the fish and wildlife regions across the country. Very little is known or publicly available about many of the species. In fact, in many cases, simply finding and making a proper identification of the species in the wild requires a PhD in biology. Yet upon the listing of any of these species, the full range of severe civil and criminal penalties provided by the ESA come into play, both for harm to the species itself as well as its critical habitat, even though the species itself is not present in that habitat. In short, private forest landowners are greatly concerned that the draconian one-size-fits-all approach of the ESA has resulted in it being used primarily as a powerful tool in the hands of those who would halt land management activities, while the actual needs of the species, including humans who inhabit the land, have become secondary. On a more personal note, in March of 2000, we had a devastating wildfire that destroyed a portion of our family timberland that contained a colony of red-cockaded woodpeckers. Most of the trees were killed that day. The rest would die over the next few months, and the woodpecker cavity trees were killed. I immediately sought help from the Fish and Wildlife Service to determine what I could do to avoid a taking, and was able to recover some type of income by selling the dead and dying timber. In response, I was sent the recovery guidelines. I explained that recovery was not a possibility since all the trees were either dead or dying. I needed information to prevent me from performing an activity that would cause a taking. Due to the threat of a litigation beyond our ability to finance and the risk of federal prosecution, we harvested what we legally could do, left the remaining timber until it could be established that no woodpeckers remained in the stand. Then we salvaged some of the wood as pulpwood, and the rest we pushed up and burned. As a result, my family business suffered a great economic loss just beyond the damage from the fire, to the tune of several $100,000. We currently have RCW clusters on other parts of our property, which require management on anywhere from 60 to 300 acres per cluster. Due to the presence of the listed species, who now own the timber, we have a loss of timber income on 600 acres of our land that equates to roughly $36,000 a year in annual growth income, plus the cost of required management services. All the management has been voluntary and self-financed since the Supreme Court has ruled that this is a partial taking and there's no compensation. Anyone, including those in this room, who has a portion of their income taken away would probably think different. The ESA process and litigation are not about saving species. It's about land control. Certainly the federal government can find a better way to help private forest landowners who provide so many public benefits rather than lining the pockets of environmental groups and their pro bono attorneys and spending money on a program that by federal government's data is a complete failure. In closing, no one, including myself, is questioning the importance of protecting endangered species. Indeed, in my particular case, I have wound up with colonies of listed woodpeckers on my land that I consider and account for in my management activities without any federal or state funding. If the ESA cannot be reformed to help ease the concern of litigation placed upon the private landowners, then the tsunami of listings and the heavy-handed tactics used by some groups threaten to do real harm to generations of forest landowners who have been and remain good stewards of land as well as to the species and their habitat. A public good should be financed by the public and not a few unfortunate private landowners. I'll take any questions. Thank you.
Thank you, Mr. Hopkins. Dr. Gerald Walker, recognized for 5 minutes.
Thank you, Mr. Chairman, Ranking Member Walls, members of the committee, and thank you especially for adding to the renewed attention to this topic, especially Ranking Member Walls, relative to your comments. I'm eager to take you up on making this a larger, serious, good faith effort to renew attention to the Endangered Species Act. And in that regard, I also would like to thank Congressman Schrader. He's working with Cynthia Lummis, one of the co-chairs of that House ESA working group, on a bill, 2919, passed by voice vote from the Judiciary Committee that would get us better data on these lawsuits. But the House ESA working group, as well as some voices from environmentalism, have recently raised ideas that could finally break the gridlock on the Endangered Species Act. Others as well. The Conservation Leadership Council, which is made of conservative leaders from across the country, from the highest levels of government and advocacy and industry, are also reviving the issue in a positive way. On the ground, helping to find solution are sportsman conservation groups like the Boone and Crockett Club, the Wild Sheep Foundation, National Wild Turkey Federation, Appalachian Wildlife Foundation, and the Rough Grouse Society. These groups are ideal partners for their focus on real results ecological expertise, and appreciation of the risks and trade-offs involved in stewardship. And I ask to submit for the record a recommendation from these and other sportsman groups from the American Wildlife Conservation Partners.
Without objection.
These are the experts and advocates who know that better results for wildlife and people come from working things out ahead of a decision instead of litigating them afterwards. The failure to work things out and the routine of litigation shows that central planning doesn't work any better for governing ecosystems than it does for governing economies. This is the core vulnerability of the Forest Service. It's working under relic laws of old ideas from the last century. And even if we perfected the Endangered Species Act, we would still have to update some of those authorities. But as to today's agenda on the Endangered Species Act, here are 4 ideas that could move us all toward working things out on the ground instead of hashing them out in the courtroom. First, because species listings force the Forest Service to reconsider its plans and policies, there should be a schedule for which species be considered for listing each year, 5 years out. We have a sort of tentative schedule like this now because the Fish and Wildlife Service agreed to one in a settlement agreement. We should have a certain schedule, authorized in law, decided in public based on science. This way, the Forest Service and everyone else would know what is coming and when, and could prepare for it, would not need to sue to push a decision, and this cramming that goes on is underway right now, especially in eastern forests, trying to catch up with the long-eared bat. I would note also in this regard a new bill this week from Congressman Nagelbauer. It's House Bill 4284, which also presents intriguing ideas for solving this backlog problem. Secondly, for similar reason, the achievement of recovery goals should be a cause for delisting, not just a consideration in that. Litigators are raising new issues at delisting now, such as we're seeing with the grizzly bear in Yellowstone. Third, we should remove deterrence and encourage active recovery efforts. Ironically, if the Forest Service or anyone else intends to help a species today, it must go through additional process to get authority to help, over and above what's required to merely avoid harming a species. And fourth and finally, we need to give states a formal role to coordinate wildlife population management on federal lands. This is possible under the Sykes Act. Unused provisions of that authority could be brought to bear. And in closing, I just want to note, with regard to the politics again, we need more workable politics. We must be able to address the issues. Some people avoid them by rejecting all improvements. Other people attack flaws without committing to improvements. I think we can do better. I think this hearing is a step in the right direction. I thank you, and I look forward to your questions.
I thank the gentleman, and I thank all the witnesses for their testimony, and something that I rarely see in the little over 5 years I've been here. They all had time to spare at the end of the testimony. So that speaks to the fact you've got confidence in your written testimony, and we appreciate that, and we'll try to follow suit, I hope, in this next phase. The chairman would like to remind members that they will be recognized for questioning in the order of seniority for members who were here at the start of the hearing, and after that, members will be recognized in order of arrival, and I appreciate members' understanding. I want to take the liberty of recognizing myself for the first 5 minutes. Mr. Pena, as the Forest Service has grappled with a long-term increase in the amount of cases that are settled on land management, especially vegetative and salvage management, please characterize how any settlements on cases involving the Endangered Species Act may have impacted decision-making regarding the changes in the use of national forests over the past 20 years.
I think the way we look at settlements, we aren't going to settle a case if we think we're going to win it. And so if we're going to if we enter into a settlement, it's because we have evaluated our case, and there is a weakness, and that we want to go back and tighten it. So in my view, the settlements have resulted in us tightening up our understanding of how better to respond to and document, probably more importantly, document how we're providing for provisions of restoring and maintaining habitat for listed species.
Thank you. Ms. Lawrence, through your study, though your study focused on reimbursement of attorney's fees, you indicate that you found some information on the broader costs associated with environmental lawsuits. To the extent any of the USDA's agencies were using an accounting code to track other litigation costs, are you able to estimate a total cost to taxpayers?
We did not have that data in our report, sir, but we do note that USDA has a code in their financial management system tracking payments, and this code does track some costs in addition to attorney fees, such as damages, but it doesn't track all associated litigation costs. The Forest Service has a separate code that tracks specifically attorney fees, and under the Equal Access to Justice Act, because the Appropriations Committee requested that. So we did not have an opportunity to report on total litigation costs.
Okay, thank you. Mr. Hopkins, you mentioned the challenges you face owning land beside a national wildlife refuge in terms of conducting timber sales. Can you relate any stories from your membership about individuals who own land adjoining a national forest and faced the related management challenges or even the threat of litigation due to the Endangered Species Act?
Since our land adjoins the U.S. Wildlife Refuge, I can tell you in 1996 we were harvesting a stand of 38-year-old planted pines, heavy dense planted pines. By all definitions of RCW foraging, it was not foraging habitat. In the process of the harvest, I received a letter from the U.S. Fish and Wildlife Service advising me that I would be allowed to continue my harvest because they had determined that the birds that were on their property had sufficient foraging, that I was not damaging the critical habitat. By every definition, it was not critical habitat. That's the uncertainty that scares people like me, that I thought I was doing absolutely nothing wrong. I could have been subject to not only extensive litigation, but federal criminal prosecution. And I might be able to survive the financial end, but I'm not sure I can do the time. So there is an economic cost, and there's also the fear of criminal prosecution is a very serious threat to us.
Dr. Childwalker, to what extent have lawsuits filed against the Forest Service under the guise of protecting endangered species impacted on the ability of the Forest Service to make management decisions designed to recover those species?
Mr. Chairman, it's has been mentioned, the Endangered Species Act itself is not really the mainstay of the litigation against the Forest Service. There's lots of causes for action against the Forest Service, but typically what happens is first the Forest Service is forced into revising plans and policies to update them for a new listing. Sometimes then there'll be challenges that those revisions are inadequate. Then there'll be challenges that the process used to reach those revisions was inadequate. And then there'll be challenges claiming that the decision in the end of the process was arbitrary and capricious.
Thank you, and I will yield back, and I'm pleased to recognize my good friend from Oregon, Dr. Schrader, for 5 minutes.
Thank you, Mr. Chairman. Appreciate the witnesses being here today. Very important hearing, and just in listening to the witnesses so far, seem to be two main thrusts that I can identify. One is the takings issue on private landowners with the Endangered Species Act and different listings, and then in my neck of the woods, which is mostly federal land, it's the use of endless litigation to deny the Forest Service the opportunity to do what they are supposed to do, which is consider all multiple uses. We rarely get to a point where there's any ability to do any harvesting in any way, shape, or form where I come from. So, opening question, if I could, Mr. Penna, is, would you suggest that the ESA application as it pertains to U.S. Forest Service and BLM land is broken? I mean, it's not working perhaps as well as it should.
Well, I would be hard-pressed to say that it is perfect in its application. I think because of that, The Forest Service is putting a lot of time into working with Fish and Wildlife Service and NIMS on how we can more efficiently implement the requirements of the Act together. I think those types of discussions, particularly in Oregon and Washington and in Region 6, have resulted in a lot of improvement in implementation of the Act, which leads to us having plans that are more effective in responding to the Act, and by extension, not quite as vulnerable to litigation.
Well, I guess I might
disagree. The fact that it's not as vulnerable.
I might disagree respectively in terms of effective. We've got a spotted owl issue in my state that has virtually shut down any harvest on federal forests. It's maybe a tenth of what it was 15, 20 years ago, and we've set aside critical habitat. I haven't heard so much on the private land, but I'm going to pay a little closer attention after Mr. Hopkins' testimony. But on federal land, and found out that after 10 or 15 years, it's made zero difference. The spotted owl is still decreasing in numbers. Studies in Northern California and other parts of the country have shown that the barred owl is actually preying on the spotted owl, and yet that only now are we getting a little opportunity to do some taking, if you will, of the barred owl to prevent the extinction of the spotted owl. And yet Forest Service's response to that was to set aside more land that made no difference to begin with. So I don't see where that's working. We have a seal issue. We're trying to, where I come from, salmon are iconic species that we try and recover. Not only the salmon broken down by species and subspecies and by geographic river they flow up, which as a veterinarian and a scientist, it has nothing to do with species. That's just a human application, an environmental application of what the original law was about. Makes it very difficult for recovery, and we now have seals that are actually eating salmon in great numbers in our dam structures that we cannot take out, even though seals are largely recovered. And so I just would respectfully suggest that I want to look at that again, and the goal of the Forest Service is to encourage multiple uses, not just recovery of species. They have to be balanced. That's the goal. That's the statute. And that's not the case. Way too much time is spent on the Endangered Species Act, and basically shut down and crippled the rural communities in my state. I'd like to talk with Mr. Schildwalter a little bit on the recovery issues. It would seem to me that, once a species, as I've alluded to in a couple of cases here, have been recovered, we have a wolf population that's recovered in my state, in addition to some others, and yet that's not enough. There's this endless litigation that goes on, and you could comment on why recovery alone shouldn't be the criteria, and what we could do here in Congress to make sure it is the criteria.
Thank you, sir. I agree it should be. That I can tell you why it's not, which is that the way the law is written, there are 5 factors the service must consider when it's deciding the status of a species, whether that means whether it needs to be listed or delisted. None of those 5 factors gives any binding credibility to recovery goals or a recovery plan. In fact, recovery plans themselves are optional under the law. So what happens then is the service basically goes through the same analysis it did when it listed the species, and litigants can raise new issues that had not come up during the recovery process, and that's how they move the goalpost, as they say. The fix, I know we're over time here, but the fix would simply be to make the regulatory or amendments to the statute that would give recovery goals more weight.
Thank you. I yield back. Hope there's another opportunity, Mr. Chairman. Thank you.
We will have. Thank you, Mr. Schrader. Now, represent the gentleman from Colorado, Mr. Tipton, for 5 minutes.
Thank you, Mr. Chairman. I'd like to thank our panel for taking the time to be able to be here. And Mr. Pinney, I just want to be able to make sure that I've got some clarity. When we've had testimony, Chief Tidwell came in, presented his proposed budget to the Natural Resources Committee. The Forest Service does not track costs associated with ESA litigation. Is that correct?
That's correct. We don't have a mechanism to track any specific cost related to any of the litigation.
I'm just a business guy. Would that be a sensible thing to do, to track some of those costs to see? Because it's certainly diverting resources that are necessary to be able to recover a species under the goal of the Endangered Species Act. Would that be accurate?
We're having to apply resources to respond to litigation, and I guess from our perspective, if we, knowing the amount of it's costing us to do litigation isn't going to change the fact we have to respond to litigation.
But if
The
we can
cost of
certainly
doing
get a
business
response
for
out of
visitors.
these committees, if we know how many dollars, if we want to recover the species, and I think we all see the value, knowing how many dollars are being diverted that could actually be used to achieve the goal. That's the point, I guess. So you would agree that it would be useful for the Forest Service to actually examine that and find out what the real costs are associated, not only with litigation, but also with costs associated for manpower that's required to be able to get the information available?
We'd be happy to investigate what it would take to be able to report on the costs.
You should have it on your books, shouldn't you?
Excuse me?
You should have it on your books. Somebody's writing a check.
Well, the cost of litigation is beyond the payment that we may do for a
But you
award.
certainly know what you're directing your people to do.
The fact that we are directing people to do work, we don't have the ability in our accounting system to finally account for everything a person does throughout the day. It's budgeted, and they do many things. Our employees do multiple things in any given day, and to be able to account for that hourly, we didn't believe and we don't believe would be effective use of our time administratively.
Interesting perspective. I'll tell you, in the private sector, we do that on a regular basis in terms of some of that analysis. But to the goal of actually being able to achieve recovery in a species. State of Colorado right now, we have the threatened listing of the Gunnison sagegrass, the greater sagegrass. In our state, working with our governor, working with local landowners, we have great recovery programs that are in place right now to be able to actually help protect the species, to be able to enhance the habitat that's going on. Wouldn't it be a sensible approach, rather than having a one-size-fits-all program going across the West, to be able to encourage these local conservation efforts?
Well, I believe that we're attempting to do that. I think when we look at what is...
Actually, the listing is still being threatened by the federal government. Why aren't we taking opportunity to be able to have those local conservation efforts, the state efforts, be preeminent as opposed to the one-size-fits-all coming in from the federal government?
Well, I don't know that that's the case, sir.
No, it actually is. That is the real threat that's going on.
My experience with that and the sagegrass listing is the Fish and Wildlife Service is taking into account the actions on private land as well as on public land. And they're trying to make a determination on the adequacy of those plans in concert. And so it is, from my understanding, what the conservation efforts that are being planned on private land, non-federal land, does have a bearing and is significantly taken into account by Fish and Wildlife Service on their decisions.
You know, and just on kind of a personal note, when I'm listening to Mr. Hopkins, does it concern you when federal policy is effectively taking land and going to be able to control that land? We have something called the Fifth Amendment to the Constitution that requires just compensation in the event of taking. We just heard some testimony that that's being impacted. Is there a real concern when we look at the litigation and some of the policy going on that it is an overreach?
I don't believe I can respond to that because the litigation that we encounter is focused on federal lands. It's not focused on private lands.
I think that we're seeing that policy actually impact those private lands. And Doctor, maybe you can answer. When we use hatcheries, do those count to recovery goals?
I believe that there's a factor for the number of individuals produced with hatcheries, especially, and again, Mr. Schrader knows more about this. I think what I know about it is from his part of the world, but the concern there is that hatchery fish that are released at an older age than the embryos and hatchling fish that are growing up wild survive differently, and so they don't give credit, I don't think, for all the hatchery fish, but for some.
Thank you. You'll bet.
Gentleman's time has expired. Now recognize the gentleman from Wisconsin, Mr. Ribble, for 5 minutes.
Thank you, Mr. Chairman. I want to thank the panel as well for being here. I would like to just kind of follow up, Mr. Pena, to some of the conversations that Representative Schrader talked about a little bit. Could you help me understand on the recovery of species? You've had some successes. Obviously, the American bald eagle, very popular in Wisconsin, as well as the gray wolf has done really well in Wisconsin. I live in a what I would describe as an ex-urban and suburban area of Wisconsin, along the shores of Lake Winnebago, a relatively robust residential area, and the bald eagle is really pretty active in that area. I can sit at my dining room table and watch them fish in the morning while I'm having my coffee. It seems to me that there is an impression by some of the outside environmental groups that they believe that animals are not able to adapt to any change in circumstances. And yet, I will take you right downtown Appleton in the middle of the city of 80,000 people, and you can watch the bald eagles fish over the Fox River. And so it seems to me that animals are, in fact, adaptive. Can you talk a little bit about that on recovery?
I wish I could. I don't have that much of a background on the adaptability, but I would say that, we have examples of species occurring in habitats that you wouldn't think they would, as well as species being more resilient than what the common knowledge would indicate. The question, I believe, comes down to whether or not that's the norm for them being able, across the range, to being able to continue to survive. I can't defend the instance of bald eagles or any kind of listed species that have to interact with increasing urbanization and how they adapt. I would suspect, like you observe, because I've observed similar things, that it happens. To the extent that it happens, how does that relate to continuing existence across the full range, I think is a different question.
Yeah, to a certain degree it is, and if we look at across the range and we pivot from the bald eagle to the gray wolf, in the Schwaming and Nicolay National Forest of northern Wisconsin, they're all over the place now. I mean, it used to be when I was a youngster doing recreation in those forests, you would never see a gray wolf. I hardly can go up there now without seeing them. And so there's been this recovery inside relatively populated areas and also out of the national forest into private managed lands. They've recovered quite nicely, actually. And my point being is I'm wondering how much research is being done, because it seems to me that when you look at the spotted owl, you look at some of these other species, recovery is happening in areas where there's a lot of human intrusion, and yet we're preventing someone like Mr. Hopkins from doing really managed intrusion, to think that these animals have no ability with which to adapt and recover in areas that are even closely managed. Mr. Hopkins, can you expound on that just a little bit?
Being adjacent to the refuge, of course, they do actively manage on their property for them, which is they're not managing for timber production, they're managing for wildlife. That's their task. That's what they should be doing. In our case, it has caused me to have stands that I cannot do any timbering activity in, again, all at my own personal financial loss because there's no compensation for that.
Yeah, and without regard to the compensation issue, do you believe that you can manage those areas and also have a robust wildlife environment?
Yes.
Okay. I want to give you one opportunity because I was struck in your written testimony. You included some information on tax reform or tax policy that you felt would help you continue to manage forests better. I'm going to give you a few seconds here at the end of the testimony to expound on that a little bit because you didn't talk about it.
And I guess the best way I could describe that would be, and I'll take a stand in my timber that's got the woodpeckers in it. If it could be thinned down to the standards that they need to have, and then tax policy would be such that would provide money instead of defending litigation, provide money for landowners who are actively managing for these species, it just seems to me that would be a whole lot better expenditure of tax money than to spend it in defending lawsuits, which wind up with what I have termed regulation by litigation. And to me, that's about the worst way you can regulate anything, is to regulate it by litigation.
And I would agree with you in that regard. Thank you, Mr. Chairman. I yield back.
Thank the gentleman. Now recognize the gentleman from Arkansas, Mr. Crawford, 5 minutes.
Thank you, Mr. Chairman. While we're talking to Mr. Hopkins, I have a quick question for you. You mentioned the red cockaded woodpecker that nests in areas that where you harvest timber. I have a question about the down timber. Is that viable habitat for a woodpecker?
No, it's not. Once the timber's on the ground, they can't utilize it anymore. It has to be standing. When I was trying to determine what to do with the burned timber, most of it was still standing. Some of it was on the ground. And the cavity trees, 4 of the cavity trees actually fell the day of the fire, and I had 2 more that stood. And the answers I got was that they had documented a red cockaded woodpecker for 435 days in a dead pine tree, dead cavity tree. And so I just continued to try to monitor the site as best I could until I finally determined there were no more red cockaded woodpeckers out there by morning and after, which I was told to do. But by that time that came, what I had was some beautiful longleaf heart pine timber that I wound up, instead of being sawed for paneling and doors and flooring, it wound up going to make paper.
So that wasn't viable habitat, and yet you waited 435 days, you said?
Well, I didn't wait that long, but I waited almost a year. I was able to document that the woodpeckers were no longer there.
And you mentioned that you made the determination about whether or not the woodpecker was present, or did...
Yes, I went out and did daily documentations on them until I could determine that there were no more woodpeckers on the site.
And your determination was sufficient? I mean, I'm just asking, were they looking over your shoulder and questioning? Could they come back later and fine you if your determination was viewed to be insufficient?
I guess they could have. They did not. They did come out and take the cavity trees and cut the cavities out of them to use for displays. But other than that, the rest of it was some letter writing and verbal conversations with U.S. Fish and Wildlife Service, trying to direct me as to what I could and could not do.
Great, thank you. Mr. Pena, I want to go back to visit with you a little bit. Looking at a study over the last 20 years, it looks like, and there's been documentation that shows that the Forest Service has prevailed in roughly about half of the lawsuits that you've been involved in. Do you have any mechanism to calculate, or have you been able to recoup any of the costs associated with that litigation? Any mechanism to track that?
Recoup costs? No, we haven't recouped any cost to litigation. If we prevail, there's no mechanism to recoup a cost, and obviously if we don't prevail, then we are subject to paying out potentially damages, but costs to the plaintiff according to the statutes that would cover the situation.
So what you shared with my colleague, Mr. Tipton, you don't have a mechanism in place to track man hours on litigation, and now you're saying you don't have any kind of a mechanism to recoup costs or to track any kind of costs. That seems problematic to me. I mean, particularly when agencies come and lay out their budget requests and so on, and you can't account accurately for the man hours that are spent in a given endeavor. Don't you think it'd be good to revisit that policy?
Well, I think if you characterize the man hours to accomplish the endeavor, the cost of the litigation becomes part of the cost of accomplishing the endeavor. If we have a timber sale that's litigated, to ultimately resolve that, the cost of the appeals, the cost of the planning, the cost of the layout, cost of the appeals, cost of any litigation that may occur is all the cost of that project. And so obviously we're not going out there, well, hopefully it's obvious, that we're not going out there to get litigated. We're going out there and we're planning to implement that project to the best of our ability, to the best of our scientific ability and collaborative ability in order to achieve the objectives of the project. And so for us to say that here's the cost of doing business or because of the litigation, we haven't been able to understand how that changes the overall outcome of what's going on.
Okay, let me stop real quick right there. So the study, which covered 20 years, shows that you prevailed in roughly half, or maybe a little more than half. So over the last 20 years, you haven't taken into consideration, as you just said, we're not going out there with the assumption that we're going to be in litigation. But you've got a 20-year history of being involved in litigation. So shouldn't you assume that there's going to be litigation going forward
So
and be
what
able to
we've-
calculate those costs?
Yeah, what we've invested our time in, rather than tracking cost, is tracking how we can better deal with the issues that were raised in litigation. And so we've focused our time more on how we deal with the science questions that is generally at the root of the non-procedural causes for loss. So questions around the science, and then improving our procedurals, because we're trying to implement about 82 different laws that guide land management. Each one of those laws have an opportunity for litigation. And generally, when you look at our litigation, there's a mix of cause for litigation. It's a pretty complex system that we've created.
Okay.
And so we being the federal government. And so it is difficult to make sure we hit the right seam so that it's perfect upon review at a court. And that's what we put our time into.
My apologies for the extra time there.
No
Chairman.
problem. Gentleman's time's expired. Now I recognize Mr. McAllister for 5 minutes.
Thank you, Chairman. Man, I'm just sitting there thinking, first of all, I want to thank y'all for coming and just trying to wrap my head around it. You know, our job up here is, one, to be good stewards of the taxpayers' dollars, and two, is protect our taxpayers. And I guess my question to you, Mr. Pena, is I come from business. And I understand you may not be tracking it, but, I mean, there's obviously attorney fees, there's scheduling, everything that goes with it. Do you budget for litigation every year? Do you have a certain amount that you put in that you expect to either lose or to have to fight against with?
No.
So over 20 years, we've had all these different lawsuits, and obviously you prevailed in over half of them, but we have no way to track the cost of what's associated with where our taxpaying dollars are being spent, whether we think it's being wasted or not, over lawsuits, whether they be frivolous or not. You're saying we have no mechanism in place for tracking the cost?
Other than for, with the Forest Service, for the cost of Equal Access to Justice Act, we don't track those other costs.
Okay. You said that, too, when you do win a lawsuit, you have no way of recouping any costs. Is there no, we're not filing lawsuits back for recovering costs when we're being found innocent?
There's no mechanism in statute for us to do that.
Okay. All right. It just seems kind of, you know, the way the normal world works, if somebody sues you frivolously, we ought to have some mechanism that we could recoup costs to stop some of these frivolous lawsuits to know that they can't sue for no reason. I guess my second, I'm really frustrated with some of the stuff you're going through, Mr. Hopkins, on you sit here and waited all that time knowing the land was not viable for woodpeckers. But yet, what is the reason you think you're not getting a timely answer on what to do? I understand the habitat and all, but it seems to me there would be some kind of work and all that you could do to continue managing, such as you said, the trees that you had to waste for wood that didn't go for premier timber, which it would have went for paneling and flooring and all that. What do you think the cause for the such long delays? In your opinion, do you think it's the agencies worried about litigation on their part if they act too quick?
I'm not sure that I can answer that question. I know it cost us somewhere in the range of several $100,000 in lost income on that. I feel like there is a hesitancy on their part to send letters out telling you exactly what you can do, because there would be some exposure on their part. And obviously the foraging issue that I mentioned earlier, by definition, my land was not foraging, but by U.S. Fish and Wildlife Service's understanding of the definition, it was foraging. So there is a lot of uncertainty. And the sad thing is the damage, the penalties that can occur, and the cost of litigation of getting sued are quite severe for that much uncertainty.
Okay. Yeah, I guess what I'm having a hard time wrapping around is, I mean, obviously most of you timber guys are great conservationists, and you believe in protecting what is your tool, which is what you make your living by. But how do we go by incentivizing for you not to be aggravated and you know, it's almost like we set up a system to where you want to circumvent the process because you don't want to deal with the option of losing your land, losing your resources, I don't know. It's pretty frustrating to sit from here just what the bureaucracy has done to the individual taxpayers at the end of the day. And, I think it's our job to try to figure out a way to fix that. And I would be open to any suggestions that you think would make. You're the guy on the ground. You're the one that faces it at the end of the day. And I believe that you truly don't want to see any species being endangered and lost from planet Earth for here on out, and do your part to preserve it. But where do you see the areas that we could really improve to try to make things working for both sides? Because I see a lot of taxpaying dollars being, I don't want to say wasted, but being spent on costly, frivolous lawsuits that if we were managing a little bit more properly, maybe that would not be the case.
I just think if the law would incentivize as opposed to punish, that would be a great start in the right direction. If I were to be economically made whole in the woodpeckers that I still have on some of my property that I'm having to actively manage for, and if I would just be made economically whole, I'd be one of the best woodpecker managers that you would have. But the process is such that when that woodpecker comes in and lights and builds a nest, he takes my timber away from me. The Supreme Court said it's not a taking, it's only partial. And so I've lost income. So landowners have a fear that if the better they manage their land, the greater risk they're going to have that a species is going to move on to it. And so it goes contra to even trying to have good forest land management, especially long term. There's a great initiative right now trying to restore a lot of longleaf pine in our area, and some of you may be aware of that. Some landowners have a fear that if they establish some beautiful longleaf wiregrass ecosystem, the next thing they're going to know is it's now going to be occupied by an endangered species, and they're going to lose the control of the management of their property.
Well, I certainly appreciate your testimony, and I don't think we want to start having raisers of red cockaded woodpeckers, but obviously I think it needs to go hand in hand and not be so costly to you that it damages you at the end of the day. So I give back my time, Chairman.
Thank the gentleman. And now recognize the gentleman from Wisconsin or Michigan, Mr. Benchak, for 5 minutes.
Thank you, Mr. Chairman. Mr. Pena, would the Forest Service support changes to the Environmental Species Act that would put more emphasis on recovery and limit the ability or all this litigation? Should we address this in Congress? I mean, would you be in favor of that?
I'd have to say that the administration doesn't support amendments or changes to the ESA. I think the Forest Service would be happy to work with the committee on ways to make be more efficient in implementing the act.
Well, it doesn't seem to me to be very efficient. I mean, some of the things that we brought up here this morning, so there's a lot of inefficiencies. Number one, legislation by litigation doesn't seem to be a very good way of doing things, especially in view of the fact that these costs are coming out of your budget. I mean, as from my understanding, it comes into the cost of selling the timber.
Yes, sir.
And to my understanding, the Forest Service doesn't really make a profit on timber sales because of the fact that there's all the other costs in there. And, as a landowner myself, it's hard to imagine someone who didn't have to buy the land not being able to sell the timber to make a profit, or show a return to the American taxpayer, because it is the taxpayer's land that you are managing for us. Mm-hmm. And you can't do it at a profit or at a return, so our school districts get a share of the money. What's the real problem in my rural district in northern Michigan, where there's a lot of federal land, and school districts depend on a portion of the timber sale to keep their schools open, and yet you guys can't figure out a way to do it and return money to the school districts. It's really a frustrating process, and it's led to the fact basically that there's not much timber sales going on in the federal forests. In my district, I mean, most of the contractors that I know have given up even bidding on federal land because, of all the issues, dealing with, federal laws and their risk. So, to me, the whole way the Forest Service is managed needs to be reformed in some way so that it's actually doing the job it's supposed to be doing. In other words, managing a resource for the people of America, which doesn't seem to be working very well right now. So you'd be in favor of reforming that in some way. I guess you say the administration is not in favor of any reform to the Endangered Species Act. Is that correct?
Yes, sir. And I would say that the comment I made earlier about the Forest Service has about 82 laws that it has to comply with in managing the national forest. ESA is but one of those.
Right. Well, it's obviously way too complex to, figure it out in a rational fashion. Mr. Hopkins, let me ask you a question. We have a lot of private timber in my area. I represent the northern half of Michigan, so we have a lot of private landowners as well, and we got at least 10,000 jobs directly related to forest and timber. But we have some issues with the Canadian lynx, as an endangered species. If an additional species are proposed for listing in our area, what impact do you expect this to have on our business from your experience?
I think it has the potential to be just as devastating as it was in Dr. Schrader's area. There's talk now about listing the eastern diamondback rattlesnake and the gopher tortoise, which inhabits almost all the coastal plain of southeastern United States. If that becomes threatened or critical habitat, then we could be looking at a situation just as serious as the northern spotted owl was for the Pacific Northwest. And it's easy to do the math on the damage it did up there. And I would envision it doing equal damage in our area.
To what effect Mr. Schrader pointed out that the reason for the loss of the owl was not at all what we had thought. Or, you know what I mean? And so that management was occurring with a lack of scientific basis, from what I can understand. Does that tend to happen a lot, Mr. Hopkins, as far as you're concerned?
I think a lot of it is based on flawed science, and a good example is the colonies that I have on my property that I have to manage for. The science says that we need 250 active breeding pairs to have a viable genetic colony. I have about 6 pair. So all I've done is define the boundary of the graveyard, or where those birds are going to die out. Whereas what to me would make good sense, based on the science, would be to come in and take my offspring from these birds for the next 10 years, move them to a recovery site, and then tell me I can do with what I want to with my property because I have done something to try to help carry on a viable colony of these woodpeckers. Because when you have the science coming a little late, as in the northern spotted owl, unfortunately, we decimated the forest industry up there before we found out the true cause of the problem with the northern spotted owl.
Thank you. I'm out of time.
I thank the gentleman. Now I recognize the gentlelady from South Dakota, Ms. Nome, for 5 minutes.
Thank you, Mr. Chairman, for holding this hearing. I certainly appreciate it. Mr. Pena, could you tell me a little bit about how an animal becomes listed on the Endangered Species Act?
It's my understanding that there's 2 ways that it could happen. It could be proposed for listing by the agency, the Fish and Wildlife Service, or it can be petitioned by a member of the public or an organization.
Is it necessarily, are there qualifications that it has to meet? Is population a consideration?
Yes.
Numbers?
Yes.
But my understanding, based
on... it's numbers and habitat. If the habitat is at risk, that could be a basis for listing as well.
Okay. I had read some articles, and it was a little while ago, but it referenced what Mr. Hopkins was talking about with the eastern diamondback rattlesnake, that it was being proposed to be included in ESA because it was considered threatened or species, that there was, because of some of the activities that happened in western states, that not necessarily the population was down, that the numbers weren't being threatened. We weren't worried about it becoming extinct. It was that because of activities that were happening to the areas that the diamondback rattlesnake were included on and where it was living was threatened, maybe even because of some of the western towns having rattlesnake roundups, that was a consideration for putting it on the Endangered Species Act. Are you familiar with that?
No, ma'am, I'm not. I'm sorry.
I'll tell you, in western South Dakota, we have a lot of concerns with the grouse as well, the sage grouse, but also looking at that kind of a proposal that could be a picture into our future. They're very concerned at where this could go and where it could lead, that any animal that is perceived by some activity to be harmed or by some outside group to be harmed, that it could be listed and therefore change our entire way of life. You know, if you're going to brand a calf, is the calf then able to be listed on the Endangered Species Act? That's really where the conversations go, because it really sees no bounds as to what the qualifications are to be included in that act. And we know when we go to Dr. Schildwalker, when he was talking about, you stated in your testimony that stopping harms is enough to recover the species, but the lawsuits aren't designed to prevent management decisions to stop perceived harm. Is that something that you concur with, that you testified to as well?
Yeah, the point there, Congresswoman, is that for most of the species on the list, simply trying not to get in its way isn't good enough. You got to actively manage a species population, just like you got to actively manage a forest if you want it to look like something that it doesn't look like today.
Well, my concern is that with saying that the Forest Service and the administration has no recommendations for changes to ESA, that we are saying that the route that we are going down is appropriate by not putting qualifiers as to the extinction of a species or lowering of the population could allow us to, in the future, have any single animal, no matter how many there are and what use they are to the landowners and the people that are utilizing that land, could be drawn in, and that would be extremely detrimental to our way of life and even the economies in a lot of the United States. So for my area, that's extremely concerning that we would say that this is being implemented properly when we're spending millions and millions of dollars fighting these lawsuits and also seeing what it's happening to the general population of people trying to make a living off of this land. I come from South Dakota where we fight the pine beetle epidemic that's going on in the Black Hills. And that has been slowed down, that effort, by lawsuits and by frivolous lawsuits that don't allow us to do our permitting on time, don't allow us to get out there and actively manage the land and make sure that we're protecting the people that live in those hills and allowing the wildlife to really utilize the acres that they need to really thrive and survive. Chief Tidwell came out to the Black Hills before we had the Farm Bill signed into law, and he talked about, we showed him some areas of the Black Hills that we have actively managed, and he talked about what a success story that it was. He also talked about the fact that we needed to look at thousands of acres when we're managing our forests rather than looking at hundreds or even just dozens of acres as we have in the past. We were able in the Farm Bill to get some categorical exclusions that was a bigger win as far as management practices than what we've had in the past. And Chief Tidwell has told us that it is potentially one of the strongest forestry titles that we've ever seen. I would hope that in the future, when we look at managing these lands and recognizing the value that timber harvest brings into thinning of these areas, not only to the wildlife and how they've benefited from that, but to the local communities, to the people that have the ability to be safe in their homes because they don't have dead and dying timber surrounding them, that certainly would be a consideration into the future. And when we write policy, when we write legislation, that you're working with us to make sure that it's of benefit not only to the people living there and to the wildlife, but to the economy as well. We used to make money off of our Forest Service land in this country. Now it costs us money, and it costs us millions and millions of dollars to continue on fighting these frivolous lawsuits that many times we're just allowing to happen by looking the other way. I think absolutely one of the things we need to look at is having you be a little bit more accountable within the Forest Service and within our government agencies as to how much money we spend on litigation to make sure we write better policy in the future. With that, I'll yield back, Mr. Chairman.
I thank the gentlelady, and we're going to do just a real quick second round. If there's additional questions, I recognize my good friend from Oregon, Dr. Schrader.
No, I appreciate
additional 5 minutes.
Appreciate the chairman's indulgence here, and I don't want to belabor everyone's time. But I think this is a really, really important issue. It's clear from listening to my colleagues here and to some of the panelists that the ESA, at least as it pertains to forests in this great country, is no longer an act to help the survival of species. It's meant to shut down forestry. That's the real world. And whether it's on private land or whether it's in the federal forest where I come from, that's the goal of some of the extreme environmental communities out there. And that's a shame. They've made originally a good law bad, and I think it begs the point that some members are raising here to look at ESA and trying to put a little bit of fairness back into it, at least get it back to its original goal, which is to recover species. That really is what it's all about, not shutting down forestry because you have an ideological agenda and don't care about the communities and big part of the rural areas of our country. I think it's a shame. There's been comments that the Forest Service doesn't have a plan to change ESA. Well, that certainly shouldn't preclude Congress, which is the legislative making body, from suggesting some changes to ESA that would put a little bit of fairness back into it and, frankly, get back to the multiple use mandate that we're supposed to have, at least on our forest lands, I'd argue, in most of our public land around the country. And to that end, I guess I'd ask Ms. Lawrence a little bit about the Equal Access to Justice Act. What was the original problem they were trying to cure there? And is there an opportunity to have a loser pays under certain criteria that might discourage at least some of these lawsuits that are indeed frivolous? Forest Service has, no offense, Mr. Pena, has a terrible record, only getting 50%. That's failure in my school district, but it does indicate that they're winning at least 50, and that might discourage some people from at least the more frivolous lawsuits.
Yes, sir. It's our understanding that part of the intent of the Equal Access for Justice Act was to level the playing field. In other words, to make sure that individuals or parties weren't discouraged from suing the government for unreasonable actions or decisions because they feared the government was so big they wouldn't be able to afford the cost of litigation. But it's our understanding there aren't provisions to necessarily go the other way if the government wins. I just wanted to make since I'm with the Government Accountability Office, I felt an obligation to say, we always push agencies to try to track data on the results and impacts of the laws and programs that they're implementing, because we think it's important to know what those results are, and sometimes it identifies unintended consequences, and it's important management data for the agencies and the Congress to have to be able to make decisions about whether or not you need to make changes. And, has the law played out as Congress intended initially? So I just wanted to make sure I made that point.
I appreciate that. And so I guess I, for one, am going to look at least as it relates to our Forest Service lands and BLM lands, some sort of equity in the access to lawsuits and who pays at the end of the day. I mean, it's fair. I don't want to discourage lawsuits, legitimate lawsuits, any more than the next person, but should be a loser pays provision, I think, in that would put a little balance back and encourage good lawsuits and discourage bad lawsuits. I guess I asked the Chief a couple questions. Are you aware, and I know you've done some changes here, are you aware of Senator Wyden's bill that talks about getting rid of survey and management criteria, changing standing, maybe formalizing some of the original changes that the Forest Service has done, talking about ecological forestry and how that applies, and then drag my time out just a smidge, whether or not you think there's an opportunity for some sufficiency language to get at preserving species by doing things the right way, having a best practices, and then calling that sufficient for ESA listing. Because I guess as I listen to this, Americans would be hard-pressed, scientists would be hard-pressed to have all the answers. It's very clear they don't about what constitutes the exact perfect way, and maybe by leaving portions of the forest intact, let nature take its course, albeit with some assistance from us by practicing good forestry practices.
So, yes, we've been working with the Senator on his bill, and we're trying to work with him so that we can support that, yes.
Well, the Senator, I think, has got a good opportunity for us to balance, I think, some of the problems out there. The one thing he doesn't address to a great degree is ESA, and that's why I ask about the sufficiency language. We were talking about some of the ecological forestry stuff as being maybe sufficient for dealing with ESA.
So we'd be happy to have further discussions on that topic. Like I said earlier, the administration isn't supporting any specific changes, but that doesn't mean we wouldn't want to talk about that and see what could work.
I appreciate that. Now you'll back.
Okay. I recognize Ms. Nome, additional 5 minutes.
Mr. Pena, when the Forest Service puts together a forest management plan, is the public allowed to make comment and stakeholders in the area?
Yes, we're encouraged.
And how long is that comment period generally?
It varies up from anywhere from 30, 45, 60 days, 90 days.
And what causes that comment period length to vary?
The complexity of the plan, the stage at which the planning is at.
Okay. And then Mr. Hopkins and Dr. Schildwachter, are landowners and stakeholders that you're aware of allowed to provide input as well? And have you done that in the past?
I have not done that, so I can't comment on that.
Mm-hmm.
Many times. The problem, though, is that this is still a central planning exercise. There's no way for the people affected by those plans locally or nationally to deliberate over those plans. throw in your best comments, you leave it up to the Forest Service, and you hope that the experts back at headquarters.
So in your experience, are environmental groups allowed to make comments during this
Yeah,
period of time
the
as
problem
well?
is, the problem is everyone is allowed, but there's no give and take over the trade-offs of the kind of costs that fall through the cracks of the accounting system, that fall through the cracks of the communities. There's no way to weigh the effects of one forest management strategy versus another one as to what it means for the school system. These things are not deliberated. They're simply commented on, and the Forest Service tries to strike the balance for everyone else. This is central planning. This is why it doesn't work.
Do you see a better way that could be implemented rather
Absolutely. There are examples around the world. A lot of them are in fishery management, where there are mixed governance models. They're not necessarily any simpler in process than what we have now, but there are ways, for example, that authority could be shared with local governments so that there's more of a deliberation between national interests and local interests instead of trying to, strike a balance in some sort of expert process.
Do you believe that we'd have less frivolous lawsuits after the fact if we had that process put in place rather than just a comment period?
I think you would, but part of the new process would have to be different rules for how we resolve disputes.
Okay. Yeah, that's good. That's my concern, is that some of these same environmental groups that do make comments come in later at different points and file these lawsuits. And then the Forest Service has to use taxpayer dollars to defend those actions in court. And if they win, they lose time, they lose money, we lose dollars, and there's a lot of unintended consequences that I think that happen. So a better process to help eliminate that, I think, would be very helpful. I don't think anybody minds. In our area, we certainly run into problems when forest management contracts and plans take a long period of time when you're constantly fighting a disease and insect battle, and you've got to make sure that you've got something in place far beyond the time period when they're going to fly and spread. But for me, then the key is to look at bigger contracts, to look at bigger plans. I think we've been very short-sighted and made too small of areas that we're willing to address because of fear of these lawsuits, that we haven't comprehensively looked at how we can stop the lawsuits and better serve and actively manage our forests. So thank you for that. I certainly appreciate that clarification, and we'll see if Congress can weigh in the future. Appreciate it. Mr. Chairman, I yield back.
Thank the gentlelady. I'll take the liberty of 5 additional minutes, or hopefully less than that. We'll see. The Endangered Species Act, I think as you heard from members on both sides of the aisle, I think we're all recognize that the original congressional intent of that it's important in terms of recovering species, that that's the right thing to do. Obviously, significant concern with of how that the law has been utilized. I believe, anyways, I have concerns with that, and much in how the frivolous lawsuits. And I at least part of that blame, I think, is put on where the Equal Access to Justice Act has been utilized. I have the advantage of having a chief of staff that was actually here at that point and a part of that process. And so, Ms. Lawrence, you had mentioned a couple things. You used words as Congress intended, and that's always important. Congressional intent gets lost at times, and within your review, within the scope and the ability that you had to review this issue, another word that you used was reasonable. And I have to wonder whether, and also in terms of you identified of folks who would use that, my belief that the original intent of Congress was folks with standing, people that had landowners specifically, that had to defend themselves against the deep pockets of the federal government. And yet this law seems like it's been hijacked by environmental groups that use it for different purposes. And I don't know if there was anything that you found in terms of any judgments that you've made in terms of what you looked at as this has been utilized. Has it been reasonable? And clearly, who has standing under the practice today compared to perhaps what the original intent of the Equal Access to Justice Act was?
Yes, sir. We did not answer that question in our prior review, but We think that if you had data, for example, and basic data about who actually got the payments, you could start to look at patterns and trends about who's bringing the litigation, who's getting the bulk of the compensation or reimbursements, and that could give you important information to determine how the law is playing out, and maybe you need to make changes to your strategy.
I would agree completely. Throw this out to the panel for anybody who wants to respond to it. You know, as I said, the Endangered Species Act is originally intended to serve an incredibly important purpose. And frivolous lawsuits have resulted, though, I believe, in making it so that our forests, which is the jurisdiction of this committee, are not able to be managed in a healthy way, in both public and private lands. And I have to wonder, and I don't know if there's any thoughts on this, that it's to the detriment of many more species. Because being an outdoorsman, being somebody, a scoutmaster for 30 years, most species require a diversity of forests. I like to relate a healthy forest to a healthy church. If I walk into a church and I see everybody with my hairline or gray hair, I know that's not a healthy church. If I go into a forest and it's all mature standing timber that hasn't been actively managed, that is not a healthy forest. And the wrong-headed perhaps interpretation and application of not just the Endangered Species Act, but many other federal regulations and laws, I think has created some real unhealthy forests. And we're talking about a few critters, species, who make the endangered species list. How many more are we putting on that pathway because we take away their habitat? And that was a long-winded question, but I'll open it up for response at this point. Please, Dr.
Sir, it's a great insight, and the thing is that we found out 5 years after we passed the Endangered Species Act, when the Supreme Court read it for the first time, that it implied something that is not expressed in the law, which is that the intent of Congress was to protect species whatever the cost. To some, that sounds like a noble sentiment. To some, it sounds crazy. But the fact is, it's impossible. There has to be priorities. And the point that you raise is probably the greatest way to make the point, which is if among the species that are on the list, only a fraction have an active recovery program, and if all the money that we spend on recovery goes to a fraction of that, then there are a host of other species that are either getting no attention or haven't even been added to the list yet for lack of an ability to set priorities, which is why something like the scheduling of listing decisions is so important. We've got to embrace the fact that not all these situations are equal, and in order to look at the optimal set of situations, we're going to have to be able to set priorities, but that's going to take a new law.
Very good. Any other?
If I could respond also.
Please.
Sir. First off, I'd like to thank the chairman and the committee for the success in passing the Farm Bill in the forestry section. I think some of the things that you provided to us in that is going to help us deal with, once we do make these decisions related to ESA, being able to implement them more effectively. When I think of the point that you raised, that is the central dilemma that we have when we come to implement ESA on the national forest. Excuse me. The species mix in any given area is not simple. And the way that we've been driven to this point with ESA is we get driven into single species management. And that makes it extremely difficult for us to maintain our mandate for ESA, let alone NFMA, to manage for viable populations across the board. And so I think you have very good insight into the challenge that the implementing agencies have and private landowners have on trying to make the law work as it requires us to protect all species. And it's a dilemma that is difficult. The northern spotted owl, I spent 20 years of my career in Region 6, so I'm very familiar with the transition because of the northern spotted owl. And we can talk about the motives and all that, but when it comes down to ESA, the challenge is when you have habitat that is going away, there are, and these are more complex questions than what we always have science to support. And that's where the rub hits. When there's uncertainty, that makes it difficult for an agency to be able to cover all the bases and make a decision that isn't going to be viewed as arbitrary and capricious. And so that's not an ESA thing per se, but it certainly is triggered by some of the questions that ESA would cause us to raise.
Mr. Chairman, I would just say if you want to have a healthy forest, you have to manage it with multifaceted management. You can't manage it for one particular species and expect the forest to stay healthy.
That sounds like a word of wisdom for a good closing there. So I want to thank the witnesses and all the members for this hearing, which I think was helpful as we continue our commitment as a subcommittee towards healthy forests. Because quite frankly, I probably couldn't live any further away from Mr. Schrader and what I do, my home in Pennsylvania, Oregon. I guess I'd have to move to New Jersey, huh? But the fact is that this is a coast-to-coast issue that we want healthy forests, because with healthy forests come healthy rural economies, and everybody wins. Before we adjourn, I invite Mr. Schrader to make any closing remarks that he has.
I'm good, sir. Thank you.
All right. Well, in closing, I just want to thank the witnesses once again, and also just to note that this subcommittee, which is just, I want to thank the members of the subcommittee for the work that it did with the Farm Bill. I do believe, I think Mr. Schrader and I believe, and that the Forestry title, which was designed around healthy forests, is probably one of the strongest forestry titles that was written. I think that's just it shows you when you have good bipartisan teamwork, and this is be an issue that we continue to work and look at as a subcommittee in that fashion. So under the rules of the committee, the record of today's hearing will remain open for 10 days to receive additional material and supplementary written responses from the witnesses to any question posed by a member. This hearing of the Subcommittee of Conservation, Energy, and Forestry is now adjourned.